Good morning, everyone. Welcome to Assembly Judiciary. Welcome to everyone here in Carson City, as well as anyone watching online through the Legislative YouTube station or Nellis. And with that, Committee Secretary, will you please take the roll?
Assembly members Cole. Here. Dahlia. Here. Gonzalez. Gray. Here. Hanson. Hardy. LaRue Hatch. Here. Marzola. Moore. Nadeem. Orentlicker. Roth. Here. Urick. Here. Chair Miller.
Here. And please mark Assembly members Marzola and Moore are presenting elsewhere. So please mark them present when they arrive. Please mark Assembly member Gonzalez present when she arrives, and please mark Assembly member Hanson absent excused. And please mark Assemblyman Orentlicker present. Thank you. With that, just a few reminders before we get started. Please make sure that you turn down your electronics. Also, we will have 2 bill presentations today. We ask that the bill presenters keep their presentations to 15 minutes, as well as we ask that anyone testifying on a bill or making public comment today keep their remarks to 2 minutes. Everyone speaking, please make sure that you state your name clearly for the record, and please also make sure that you spell it so that we have it accurate for the record. Please mark Assemblywoman Hardy present as well. With that, today our phone number is 888-475-4499. So those wishing to call in to testify or to make public comment today, the meeting ID is 873-384-86363. And today our first bill will be Senate Bill 120, which revises provisions relating to the administration of justice. And so I will give you all a few moments to get settled in, and then when you are ready, please proceed.
Good morning, Chair Miller and esteemed members of this committee. My name is Soraya Bonner, Soraya-Bohner, and I have the privilege of being Senator Scheibel's intern for this session. Today I'll be introducing SB 120, which addresses inequities in how our state's judicial system imposes and collects monetary penalties, as well as how it treats defendants who cannot afford legal representation. This bill is grounded in a simple yet powerful principle: justice should not be contingent on wealth. For many people, a court-ordered fine can become an overwhelming burden. What might seem like a manageable penalty on paper can quickly spiral into a long-term debt for someone living paycheck to paycheck. Missed payments can trigger late fees, collection costs, or even incarceration. This is often a result of a complete inability to pay, not because a person is unwilling to pay. This cycle not only punishes poverty, but perpetuates it, making it harder for people to rebuild their lives. It is important for people to answer for their crimes, but it is important to also maintain equality. When we appoint public defenders, we do so because we recognize that access to legal counsel is a fundamental right, not a privilege reserved to those with wealth. This bill attempts to remedy financial barriers to justice across the state of Nevada. I will now pass this to Nick Shepak from the Fines and Fees Justice Center to give an in-depth background and description of this bill. Thank you.
Thank you, Chair and committee members. My name is Nick Shepak, N-I-C-K-S-H-E-P-A-C-K. I am the Nevada State Director of the Fines and Fees Justice Center, here to present SB 120 today. I first want to start by thanking representatives from Clark County and the Judges of Limited Jurisdiction for helping us ensure that we got this bill amended to a place where everybody is happy. And I'm also very proud to say that this moved out of the Senate unanimously. And with that, I will give us some brief background. I won't be as quick as John McCormick, but I will do my best.
And Mr. Shepak,
Yes.
You don't know if we're happy yet, so continue.
That's my goal.
Okay, we're ready.
All right. Thank you very much. The Fines and Fees Justice Center ran a national study with the Duke Law School, and what we found is that fines and fees impact a large portion of Americans. 1 in 3 Americans have been directly impacted, And some of the things they report is 98% reported impact on their daily life, 35% had challenges obtaining food, an absolute necessity, and 27% had housing hardship. So the fees that we're looking at eliminating today are simply the fees that are only charged on our most indigent defendants, people who cannot afford these fees to begin with, and that is why we targeted these two specific fees. So when we look at payment plan fees, we were able to contact 40 justice and municipal courts across the state. Four of those courts had a sliding fee schedule, so depending on how much you paid or how much you owed, the fees would go up. We found almost half of the courts, 19, do not have payment plan fees right now. 2 courts had $10, 1 had $20. You start getting up into the higher numbers, though. You see some courts charged as much as $50, $75, or $100 to get onto a payment plan. What this means for an individual is if you get a traffic ticket or any other type of citation or monetary sanction and you're in half of the courts, it is free if you have to get on a payment plan and you cannot afford that. However, if you end up in one court, it may be as much as $50, while another one is as much as $10. This inconsistency breeds unfairness in our system and creates a significant financial burden for individuals who clearly cannot pay in full, and we reward those individuals who have the monetary reserves in order to pay their financial penalties in full. When we look at the history of indigent defense fees or public defender fees here in Nevada, right, in 1963, Gideon versus Wainwright established the right for indigent defendants to have counsel. In Nevada, in between 1963 and 1975, there was no ability to charge these fees. However, AB 70 in the 1975 legislature was brought forward. From reading the minutes, what it appeared, the conception appeared to be that individuals who had plenty of money were abusing the system because there was no indigency test, there was no set standard, and people, according to legislators at that time at least, were saying, hey, I'll take the public defender, and overburdening the system. So they created this ability to charge these fees in order to push people out of the system. Since then, we have done a ton of work. We now have indigency standards. We now ensure that everybody who uses the public defender's office, in fact, needs a public defender. So the law is no longer working as intended. We also reached out to all of the courts. 10 justice and municipal courts in Clark and Washoe do not charge any public defender fees. 10 rural counties, the counties report to DIDS and they report collectively, so that would be their justice courts, their municipal courts, and their district courts. 10 of the rural counties do not report charging any public defender fees. On the other side, 7 justice and municipal courts in Clark and Washoe charge defender fees. 4 of our rural counties do, and then both of our district courts in Clark and Washoe report charging defender fees. But it's not just location that creates these disparities. What we see is that you have to end up not only in the wrong court, but when we get judge-level data from the courts that we could, we found that, for example, in Clark County District Court, 5 judges assessed defender fees on 75% or more of their defendants, while 8 judges assessed defender fees on less than 5% of their defendants. What this shows us is that not only do you have to end up in the wrong court in the state, you also have to end up with the wrong judge in the state for you to have this fee levied against you. In Sparks Municipal Court, to bring it up north, 1 judge was found to be 23 times more likely to assess defender fees than his counterpart right next door in the next courtroom. So we're really trying to bring some consistency here. Collection rates vary across the state, as you can see here. But I think one of the most important things to realize is that 7 out of the 11 courts in counties that charge defender fees in 2023 collected less than $10,000, the majority less than $5,000. This debt follows people into incarceration. It ends with them in debt collection services, and we rarely recoup the funds. There's additional issues is that the way that individual rural courts report to DIDS, there's a high chance of double dipping unintentionally. A defender fee is assessed, the person is incarcerated, portions of that fee are collected over time, in lieu often of restitution because it now is another line item in the collections. and that gets reported in quarterly reports to DIDS. The state is paying out if a county hits the maximum contribution formula, and we likely are at times paying counties twice for the same level of defense, just because we have no real mechanism of following this money in our rural counties. And as I mentioned, when this money is, an individual goes to trial, is found guilty, has his fee levied against them, ends up in the Nevada Department of Corrections, it's often lumped in with court fees and restitution, which reduces an individual's amount of deductions that are going actually to victims, and is actually directing this money back to courts, cities, and counties. So with that, we'd be happy to take questions. Again, the real goal here is building consistency across the system and eliminating these fees that target our most indigent individuals in the system. Thank you.
Thank you for your presentation. At this time, I don't see any questions. Not seeing any questions, I will go ahead and open it up for testimony. So we will begin here in Carson City. Anyone wishing to come and testify in support of Senate Bill 120?
Good morning. My name is Tia Smith, T-I-A-S-M-I-T-H. I'm a policy attorney with ACLU of Nevada. We support this bill and we urge the committee to support it as well. Thank you.
Thank you. Is there anyone else here in Carson? Also not seeing anyone in Las Vegas. Broadcasting, will you open the lines?
If you would like to testify in support of Senate Bill 120, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of Senate Bill 120, please press star 9 now. Chair, there are no callers wishing to testify in support at this time.
Thank you. Then I will open it up for opposition testimony if there's anyone here in Carson that would like to oppose Senate Bill 120. Not seeing anyone here or in Las Vegas. Broadcasting, will you open the lines?
If you would like to testify in opposition to Senate Bill 120, please press star 9 now to take your place in the queue. Again, if you would like to testify in opposition to Senate Bill 120, please press star 9 now. Chair, there are no callers wishing to testify in opposition at this time.
Thank you. Then I will open it up for neutral testimony, beginning here in Carson. Not seeing anyone in Carson or Las Vegas. Broadcasting, will you open the lines?
If you would like to testify in neutral for Senate Bill 120, please press star 9 now to take your place in the queue. Again, if you would like to testify neutral for Senate Bill 120, please press star 9 now. Chair, there are no callers wishing to testify neutral at this time.
Thank you so much. Then I will welcome the bill presenter up for some final remarks.
Thank you, Nick Sheepak, for the record. I just want to thank the committee for their time, and if any of those questions that were not asked do come to mind, I am happy to answer them and always available. Thank you so much.
Oh. Thank you so much. With that, I will go ahead and close the hearing on Senate Bill 120 and open the hearing on Senate Bill 141. Senate Bill 141 revises provisions relating to local facilities for detention. Welcome, Chair Scheibel. Are you the only one presenting? Okay, so whenever you are ready, please proceed.
All right, thank you so much. It is wonderful to be in Assembly Judiciary for the first time this session. My name is Melanie Scheibel. I am the senator from District 9 in the southwest portion of Las Vegas, and today I am proud to present to you SB 141. SB 141 was a collaborative effort with a number of law enforcement agencies and government agencies that run county detention centers or jails. So we're talking about facilities where individuals are housed and they're either serving a sentence of less than 1 year on a misdemeanor conviction, or they are awaiting trial on felony charges. What SB 141 does is it requires any detention center or jail facility to develop a policy regarding how they are going to interact with individuals who come into their custody who are transgender, gender nonconforming, or gender non-binary. You are looking at, or I hope you're looking at, the first reprint of the bill, which reflects an amendment that was, like I said, made in collaboration with law enforcement agencies and the governments that run these detention centers and jail facilities. So I'm going to walk through the bill with you because I think it's important to understand what the bill does and what the bill doesn't do. It is one section, but it has numerous subsections. So if you're looking at Section 1, Subsection 1, this explains that every one of those agencies is going to have to develop a policy. That means the policy has to be in writing, and that policy has to be made available for inspection. The policy has to have a couple of different aspects to it. The first one is subsection A. I think this is very simple and straightforward. Subsection A says that in any jail or detention center, we have to use respectful language with everybody who we interact with, including people who are gender nonconforming or transgender. Subsection B simply prohibits discrimination. This is already illegal, but the purpose of subsection B is to ensure that it is included in the policy so that it is easy to find and everybody understands that it applies equally to discrimination by people for their religion, their race, their creed, their nationality, their national origin, sexual orientation, gender, and gender identity. And subsection C is where we start to get into some of the more specific policies that have to be included. You'll notice that throughout the bill, it utilizes this terminology to include or incorporate by reference. So that means that the policy can either specifically spell out a policy for the people who come into custody who are gender nonconforming or transgender, or it can simply refer to another policy. So it might just say that, pursuant to policy 1.35, this is, people will be housed according to policy 1.35. Section C is, of course, the housing section. All Section C says is that individuals who are transgender or gender nonconforming must have the opportunity to express a preference for where they are housed. It doesn't say that preference will be honored. It doesn't say how that preference will be considered in terms of safety, in terms of practicality, in terms of enforceability, but that the policy that the jail implements must have the opportunity for the person to be heard and express a preference. Beyond that, the policy should follow the normal guidelines that any policy follows for a jail or detention center. It should prioritize people's safety. It should prioritize people's dignity. It should prioritize having respect for people who are both in custody and who work in jails and detention centers. So subsection C simply says that the policy on transgender and gender nonconforming people must include a section about housing. Section D includes a section on searches. The reason that we included this is that actually most of the jails and police enforcement agencies that I talked to already have this. It's very common within their jail policies especially for women who are incarcerated, to include a policy on searches. And so the policy on searches has to have two essential elements. Number one, again, the person must be allowed to express a preference. This is what most policies already include across the state of Nevada for every person who enters the detention center. Some of them are more specific to when that preference can be expressed, who they have to express it to, how they express it. And SB 141 allows for variety in that area. It simply says that every person preferably every person, but at least every person who is transgender or gender nonconforming, gender non-binary, has the opportunity to express the gender of the person they would rather have conducting a search. And the second part of the subsection D includes that the policy must prohibit searches that are simply for the purpose of observing a person's genitalia. Unfortunately, this has happened in other jurisdictions. We are very fortunate that we've not had lawsuits in Nevada at this point due to bad actors who are employed by jails and detention centers requiring or requesting that people strip down to observe their genitalia. But in other states, other jails, detention centers, police agencies have had to pay out lawsuits to transgender and gender nonconforming people who were required to take off their clothes in an inappropriate setting so that somebody could inspect their genitalia for no purpose except to harass and humiliate them. So subsection D of subsection subsection 2 of subsection D requires that the policy include this prohibition. Subsection E of the bill requires that the policy on trans and gender nonconforming folks include a section on medical care. People who are transgender or gender nonconforming are not entitled to any kind of medical care in detention or jail that anybody else is not entitled to. They are, however, entitled to care that is consistent with the standard of care. And so what we are requesting in SB 141 is we are requiring that the police organization, the law enforcement agency that runs the detention center or facility, include in their policy that transgender people are also entitled to medical care that meets the same standard of care for everybody else in the jail or detention center. Subsection F refers to clothing and commissary items, and it says that the policy should include provisions for allowing access as practicable to the clothing and undergarments and hygiene items that the person requests. We utilized that terminology to the extent practicable through an amendment because that was language that the organizations that oversee these jails and detention centers felt encapsulated what was realistic. So what we're saying is that, consistent with the housing policy, let's say that you have a transgender woman who is still housed in the male facility, but they require or they request a bra. It would be SB 141 would require the jail or detention center to consider that possibility and have a policy in place before it happens. I understand that there are safety concerns about providing undergarments to somebody in a housing facility where they're not normally provided with those undergarments. This is not prescriptive. It doesn't say you have to provide a bra to a transgender woman who is housed in the male section of the jail. It says that you have to have a policy. Are you going to provide it only when they have, access to certain facilities or when they don't have access to certain facilities? Are you going to provide it only in the, north wing but not the south wing because it's closer to the commissary? Every jail and detention center will be able to develop their own policy, but they have to take that into consideration and put in writing beforehand what kinds of undergarments, what kinds of hygiene items are people going to be able to have access to. In this process, we also learned that different hygiene items are available in the commissary in different parts of the jail. And not just things like tampons and pads, but even the deodorant that's available, the soap that's available, sometimes varies in the men's section and the women's section. And so the law enforcement agency will have to develop a policy that simply says either we will, we won't, or we might allow people in the women's section to purchase the deodorant, which is normally provided in the men's section. So subsection F requires that they consider in advance how they're going to handle requests for hygiene items, clothing, especially undergarments that are not normally provided in the area where they're housed. Subsection G requires that the policy also include a provision for juvenile or youthful offenders. And it is that simple. They have to determine whether they're going to have all of the same applicable policies as adults who are gender nonconforming or gender non-binary, or whether they're going to have a separate policy for juveniles. This is in alignment with most other jail and detention center policies. In most other aspects of the administrative regulations, there is a section for juveniles, and it varies throughout the state whether juveniles are treated exactly the same as their adult counterparts, whether they have a completely separate administrative regulation, or whether it's a combination of the two, where in certain sections, perhaps for the clothing, the juveniles will have the same policy as the adults, but perhaps for housing, they'll have a different policy from adults. And so subsection G requires that the agency that oversees the detention center or the jail includes that in their policy. Section H includes a grievance process. So a transgender, gender nonconforming, gender non-binary individual in custody who believes that their rights have been violated, believes that the policy has not been followed, has to have some process for redressing their concerns. This is very standard, dare I say. Again, we have the terminology here, include or incorporate by reference. In all of the jails that I spoke to about this, they have a process where you send a kite to admin to address any grievance, and that would be sufficient. So I would anticipate that most policies would just incorporate their usual grievance policy, but I guess they could have a separate one if they wanted to, if there was some reason to. Subsection 2 is strictly permissive. It does allow a sheriff, chief of police, the agency that oversees a jail or detention center, to implement training and education, but absolutely does not require it. Subsection 3 clarifies that this is intended to apply to jails and detention centers as they currently exist. This bill does not require any agency to build new facilities, to hire new staff, to develop new programming, none of that. It requires that in the jails where they already exist, they implement a policy for handling transgender and gender nonconforming people who come into their custody. That is the bill, as briefly as I could, and I just want to take a moment to kind of express the importance of this, because I think you all know me, and I do come before you often advocating for the transgender community, and I will do that until my last day in office and probably beyond then. This is also about law enforcement, and this is also about our local governments, because the purpose of putting a policy into writing is to do what lawyers like best, is to provide a map, to provide a guide, to provide guardrails, because right now, Nevada jails and detention centers that don't have policies, and by the way, most of them do, but the ones that don't are in a very precarious position. We've seen across the country transgender, gender nonconforming, and gender non-binary individuals sue jails and detention centers and win because they have not been treated with dignity and respect. You heard me talk a little bit about that with those unfair, strip searches, but it goes beyond that. And I think that here in Nevada, we have an opportunity to get ahead of the curve. We have the opportunity to develop a policy proactively. And here's what that would do for us. That would allow us to reduce the debate, to avoid lawsuits, and ensure that everybody is on the same page. We don't have to agree about the page. We don't have to agree about how we think transgender and gender nonconforming people should be treated, but we can agree on what a policy says. And so what this will do is this will ensure that in 6 months, 12 months, 2 years, when a transgender person is incarcerated in Nevada and they feel like their rights have been violated, we all turn to the same page to determine whether or not that is the case. Because the policy will say either they were supposed to get this thing they believe they were entitled to, or they were not supposed to get that. So I'll use the housing as an example. Having a policy in place that includes allowing a person to express a preference for their housing without prescribing where they have to be housed would cut off the opportunity for an individual to sue based on having simply not been housed where they wanted to be housed if the policy is clear about what the considerations are when choosing somebody's housing. It would also be clear that they have to have the opportunity to express a preference. And so we would be able to ask, did this person express a preference? And did the jail or detention center follow their policy to place that person, whether or not that placement is consistent with their preference? Without a policy in place, we leave the courts to determine if everybody has a right to be placed where they prefer. We leave the courts to determine how jails are required to deal with preferences of people who are incarcerated. We leave the courts to determine if it is reasonable for the jail to house somebody in a place where they don't want to be housed before even hearing their preference. By eliminating those questions and putting a policy into writing, we develop a roadmap for everybody to ensure that we agree about what the standard is, and we can ensure that every single jail and detention center is held to that standard, which provides only a very, very low baseline of treating people with dignity and respect. And with that, I'm open to questions.
Thank you so much for your presentation. I'll say that the part that I highlighted that I appreciated the most was, I had started and ran a prisoner reentry program before I moved here to Nevada. And with selecting people to work in the program, because most of my staff were housed in the jails and prisons and parole offices, but there was a certain questioning that came. There's a morbid curiosity or fascination with incarcerated individuals. And so when I see something like prohibits an unclothed search for the purpose of just observing to feed that curiosity or fascination, or even worse, I really appreciate that, because there would be questions that would come up, and it was clear, I'm not sure if this is the right placement for you. But I'm also encouraged to hear that this is not or hasn't happened in Nevada yet. So I'm very encouraged to hear that, and of course, let's maintain that. We do have some questions. We will start with Assemblymember Roth.
Thank you, Chair, and thank you so much for that presentation, Senator. I appreciate this piece of legislation so much. I am a public defender and have served a lot of members of the transgender community, and I see how much a lack of a policy has impacted them, especially in pretrial detention. So I have received a lot of, frankly, hateful emails in the last few hours regarding this bill, and I think that it is based on a misunderstanding of what this bill just fundamentally does. And so how I read this bill is that it is very narrowly tailored to addressing the ability to provide some level of dignity to people who are incarcerated pre-trial or serving shorter sentences. So can you just clarify, this does not require any law enforcement agency or sheriff's detention center to house someone specifically. This is in regards to providing certain dignity to individuals who are currently in custody.
Melanie Scheibel, for the record, thank you. Yes, I think you stated it perfectly. It does not require any particular housing decisions, and this does apply to jails and detention centers where people are generally awaiting pretrial detention, or they're in pretrial detention awaiting trial, so they also have not been convicted of a crime.
Thank you. Our next question is from Assemblymember Cole.
Hi, thank you very much for the presentation. I agree that having a policy is a good practice. I think that it makes sense because it provides sort of a standard of care so that the staff understands what they need to be doing, and then potential incarcerated people, they also know what to expect. So my question is, in Section 1, subsection 1, D2, when we're talking about the unclothed searches, understanding that there are times after the first intake that there may be a need to search for contraband or something like that, can you just give me an idea of what reasonable grounds would look like? Thank you.
Melanie Scheibel, for the record, thank you so much for that question. We did workshop this language with law enforcement agencies that run jails and detention centers, and I think you hit the nail on the head. Searching for contraband might be an example of a reasonable grounds that exists to do an unclothed search.
Sure.
Thank you for that. Is that the only grounds, or would there other things?
Melanie Scheibel, for the record, reasonable grounds is supposed to be a little bit generalized, because I'm sure there could be other examples. I can't think of one off the top of my head.
But to follow up on that, Chair, this bill does not remove any of the current or consistent policies around those searches. It's just it would just prohibit just doing it for giving some arbitrary reason with the intent behind, which is just curiosity or worse. Is that correct?
Melanie Scheibel, for the record, that is correct.
Thank you so much. Our next question is from Assemblymember Gray.
Good morning, Senator. Who's going to be the arbiter on whether or not these policies are appropriate? I mean, if a county wanted to have a policy, especially in the smaller counties where inmates will be treated according to their biological sex, that's in the way we have to do it, I mean, manning, everything else, but I mean, who's going to be the arbiter of that?
Melanie Scheibel for the record. As long as the policy meets the requirements of SB 141, which includes allowing the incarcerated person to express a preference, the jail could still utilize any factors that they think are relevant to determine where they're going to house people.
Our next question is from Assemblymember LaRue Hatch.
Thank you so much, Chair, and thank you for bringing this. As I was going over this bill, it actually reminded me quite a bit of SB 153 from last session, which you presented to us. And that was, from my understanding, a lot of similar language, but on Department of Corrections. And I was happy to see that was supported with bipartisan support and signed by the governor. And so I just wondered, could you speak to the ways that these are similar?
Melanie Scheibel for the record. Thank you. Yes, this is absolutely an extension of SB 153. I actually think this one is better. I think we did a better job honing in on what exactly the requirements should be of the policy and which sections the policy should address, but the intent behind both is the same, to provide that roadmap and ensure that people, even when they are incarcerated, are treated with dignity and respect. And I hope that this one will also receive that bipartisan support in the governor's signature.
Okay, not seeing any additional questions, I will go ahead and open it up for testimony. So those wishing to testify in support of SB 141, starting here in Carson, again, just a reminder that you need to state your name and spell it so we have it correct for the record. And also, please limit your comments to 2 minutes. Any comments you have that are longer than 2 minutes, you are more than welcome to submit in writing to the committee. And of course, as always, it goes without saying that I expect respect for all positions and all people. So with that, please proceed.
Good morning, Angela Knott from the Washoe County Public Defender's Office, ANGELA KNOTT. We are in support of SB 141. And to kind of go off of what Assemblymember Roth said earlier, we represent transgender individuals in our office. And recently we had one that was housed at the Washoe County Jail for over a year while she awaited trial and sentencing. At first, it was a little confusing for her. She was placed in the male unit and in the protective custody unit. And she was confused as to why, A, she was in the male unit, and B, protective custody. Why that was interesting to her was because each unit has different access to different resources. Some of the units you can have jobs like work in the kitchen, protective custody, not so much. But as time went on, because we learned that the Washoe County Sheriff's Office actually already has a policy for transgender individuals, and I won't say a success because I don't like incarceration in general, but she was safe. She made it to all of her court appearances. She was never put in the infirmary for a violent act. And while there were some issues also getting her medication, it eventually got worked out. So there are still bugs that need to be fixed, but I think having a universal, at least in Nevada, policy and procedure on how we're going to house these individuals is super important for everybody involved. So for those reasons, we support SB 141.
Good morning, Chair Miller and members of the committee. My name is Kayla Maese, spelled Kaylahmaese. I'm a civil rights analyst at the ACLU of Nevada. The ACLU does support SB 141 and putting proper policies in place in writing that our facilities are able to use all together at the same time. So we support this bill and we urge the committee to support as well. Thank you.
Thank you, Chair and committee members. My name is Nick Shepak, NICKSHEPACK. I'm the Nevada State Director of the Fines and Fees Justice Center. We work with people in every single part of the criminal justice system, which includes a large number of individuals in pretrial detention in our local jails. one thing we have found consistently is that when policies are in place, that is the roadmap for the individual during incarceration. I will tell you that many incarcerated individuals do not like the policies necessarily. However, when they are clearly stated, people know where they stand. They're able to focus on their cases. They are able to focus on what they need to be focused on instead of in this limbo of, am I being treated correctly or legally or not? And so simply putting these policies in place, regardless of how each individual feels about the policy, is better for everyone involved in the system. Thank you.
My name is Rihanna Josiah Iverly.
Could you please spell your name first?
Oh, which part?
Both.
Rihanna.
Your first and last name, please.
First name, Rihanna. It's Ryeanna. Josiah, capital A-J, excuse me, I'm sorry, J-A-H-S-I-A-H. I'm a little nervous. And my last name's Iverly, I-V-E-R-L-Y.
Please proceed.
Okay, first of all, I am in support of SB 141. The only reason that the state has not been sued is because this journal contains a reason why they should be. And the SB 141 has the chance to save lives because this journal also states that. This was my incarceration. Transgender people, this is the shirt I wore that day that I was arrested. And it was tore off me in the jail by men. I don't know how they're supposed to be treating people, but I know that doesn't feel like dignity to me. All I have to say.
Thank you so much for your testimony. Next.
Thank you, Chair, members of the committee. Harrison Epstein, legal extern, Clark County Public Defender's Office, Harrison Epstein. Quite simply, this bill is a step forward in protecting the rights and dignity of incarcerated transgender and non-binary people, creating policies that acknowledge, respect, and affirm the gender identities of incarcerated people will benefit their mental and physical health. This bill will lead to better consistency and better rehabilitative outcomes for transgender people in prisons and jails. We also want to commend any and all ongoing work by prisons, jails, sheriffs, and law enforcement on this matter and in this field. Thank you.
Good morning, Chair Miller, Vice Chair Marzola, and the Assembly Committee on Judiciary. My name is Chris Reese. It's R-I-E-S, and I represent the Las Vegas Metropolitan Police Department. At the Clark County Detention Center, we currently provide a safe, secure, and humane environment for all inmates. Transgender inmates are no exception. I'd like to thank Senator Scheibel and the other stakeholders on the work put into this bill and taking our concerns into consideration. We do currently have a policy that this bill addresses, and I'd further like to highlight that we are accredited by the American Correctional Association and the National Commission on Correctional Healthcare, and we do support SB 141. Thank you.
Good morning, Chair Miller, members of the committee. Jason Walker, Jasonwalker, representing the Washoe County Sheriff's Office, as well as the Nevada Sheriffs and Chiefs Association. Supporting Senate Bill 141. It is and has been the policy of the Washoe County Sheriff's Office to receive, evaluate, house, and provide safe and humane custody of all persons. We are very appreciative of Senator Scheibel's willingness to work with the stakeholders involved and are pleased with the outcome. Thank you.
Good morning, Chair, members of the committee. My name is Tara Webster, T-A-R-A-W-E-B-S-T-E-R. On behalf of the Progressive Leadership Alliance of Nevada, we're in support of SB 141 because we believe that trans and non-gender conforming individuals deserve dignity and respect. Thank you.
Thank you. Not seeing anyone else here in Carson and no one in Las Vegas. Broadcasting, will you please open the lines?
If you would like to testify in support of Senate Bill 141, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of Senate Bill 141, please press star 9 now.
Good morning, Chair and committee members. My name is Jessica Munger, Munger, representing Silver State Equality, Nevada's statewide LGBTQ+ civil rights organization. We are in strong support of SB 141 in order to create policies that support the dignity and respect of all people who find themselves in jail in Nevada. Thank you so much.
Thank you. Next caller.
Sir, there are no other callers choosing to testify in support at this time.
Thank you. Then I will go ahead and open it up for opposition testimony, beginning here in Carson City.
Good morning, Chair Miller and committee. My name is Jim DeGraffenreid, Jimdegraffenreid. I'm Nevada's Republican National Committee man here today in opposition to Senate Bill 141. Amendment 254 to this bill has not resolved the bill's underlying problems. Whether an inmate ends up housed with inmates of the opposite sex or simply wants to openly identify as the opposite gender among inmates of the same sex as the bill requires, they and others in the facility are still in danger. In public society, individuals can generally identify and present as whatever gender they choose without a problem, but there are places such as the military, sports, and indeed prison, where doing so may infringe on others' right to privacy and in some cases is actually dangerous. This bill may put jail staff in danger and also endanger and infringe on the right to privacy of gender-conforming prisoners. It may also expose the government to litigation risk. Even under the amendment, inmates have the right to request to ask for a transfer, and some may actually end up housed with inmates of the opposite sex. In states where gender nonconforming inmates have been housed with inmates of the same gender identification, sexual assaults and harassment follow. Consider the gender nonconforming Rikers inmate in New York who received 7 years for raping a female inmate in 2021 while he was housed in the women's jail. Or the case of Tremaine Carroll, a transgender-identified Third Strike California convict with a lengthy record of criminal violence who has been transferred out of the women's correctional facility and back to a men's prison after being indicted for rape. Why is there more concern about how an inmate chooses to identify than about the correctional officers who work to keep dangerous criminals off the Nevada streets? Non-conforming inmates can easily protect themselves in prison by simply identifying as their actual biological gender while incarcerated. By definition, incarcerated criminals give up freedom. Sorry, I got lost. And one of the freedoms that is necessarily given up is the freedom of gender expression. We respectfully urge this committee to vote no on SB 141. Thank you.
Hi, my name is Andrew Quinn, AndrewQuinn. The late Senator Daniel Patrick Moynihan from the state of New York very astutely observed that everyone is entitled to their own opinion, but not everyone is entitled to their own facts. And the fact is there are two genders, male and female. That's it. You're either born a male or a female. And evidence of this, you might remember when archaeologists discovered the skeletal remains of a person that was, I think, about 6,000 years old, and they named those skeletons remains Lucy. Why did they do that? Because it was a female. There was no transgender this or that. Also, if you look at the difference between the NBA and the WNBA, in an NBA game with the men, there will be dunks all the time. With the WNBA, with the women, there's rarely a dunk. Why is that? Because there's a difference between men and women. You can take parts off of a Nissan, but it doesn't make it a Ford. It's still a Nissan. Thank you so much.
Thank you. Is there anyone else here in Carson City wishing to testify in opposition? Not seeing anyone, and there's no one in Las Vegas. Broadcasting, will you please open the lines?
If you would like to testify in opposition to Senate Bill 141, please press star 9 now to take your place in the queue. Again, if you would like to testify in opposition to Senate Bill 141, please press star 9 now.
Good morning, Bob Russo for the record, and that's spelled, the last name is spelled R-U-S-S-O. I oppose SB 141. In my opinion, it presents, especially in the case of a biological male who identifies as transgender, being placed into a woman's correctional facility, a huge safety risk for those women. This bill prioritizes a woke political agenda over safety and security in our jails. To my knowledge, this bill also contains an unfunded mandate that will require local counties to cover the cost. Many counties are already in fiscal hot water, yet this bill will increase their financial cost. How much will it cost? And where is the additional money going to come from? Again, I believe this bill presents a safety risk, especially for female prisoners. And along with this risk comes extra liability. And for the above reasons, I ask you to please oppose Senate Bill 141. Thank you very much.
Thank you. Next caller.
Yes, Yolanda Canuck, Yolanda, last name Knaak. Actually don't have a problem with sections A and D. I have a most problem with C, housing all bio males. They should go to male prisons. We need to protect our women. And so I'm opposed to having transgender women in the women's jails. We need to protect the women. Then also, just a general comment about this bill. The language needs to be tightened up. Otherwise, correctional officers could be sued. I think this bill could actually promote lawsuits. So please vote no. Thank you so much.
Thank you. Next caller.
Caller, you are unmuted and may begin.
My name is Devin Livesey. First name is Devin, D-E-V-I-N. Last name is Livesey, L-I-V-Z-I-E-Y. I am the Vice Chairman of the Clark County Republican Party, and for the record, I am opposing this bill. Aside from the numerous rapes that have happened in other facilities across the country when biological men who identify as women are placed in women's prison, there is also the fact that in many of our counties, this has already been addressed and policies are in place. There was a bill on this 2 years ago that addressed this that was signed into law. It seems like it's just regurgitating the same thing that was talked about 2 years ago and has already been addressed and being implemented. Also, there's the cost to, whether it's implemented or not, just the cost of creating the policies again across the state will run into a financial burden for some of the smaller counties also. And for these reasons, I oppose this bill.
Thank you so much. Next caller.
Hi, my name is Katrina Ivanov, I-V-A-N-O Frank. And I just wanted to say, if you want a transgender jail so bad, just make a transgender jail. Don't encroach on women's safety and rights. If you think there's so many transgenders that need to be housed separately from whatever they think they are, or yet maybe you should just bring back the places where people with mental disorders can go, because those are closed, and now we have this craziness going around. Not just about that, but a bunch of the homeless are also not okay and should be housed in special facilities that are not jails. So please represent me, I'm a constituent. Please vote no on this bill. The way it is written, it protects some, but it takes away from the rights of others. So that is absolutely not fair. And also, if you put this into law, you put in Nevada in a position that we can lose federal grants and federal money because President Trump announced it only to official genders. And if you're going against that, the federal government will have cause to not send federal money our way. And quite frankly, you're trying to raise our taxes again, which means we need money. So please don't vote on things that would make it possible for us to get less money from the federal government. Thank you so much and have a lovely day.
Thank you. Next caller.
Hi, good morning. My name is Kimberly Johnston Linsday, Kimberly Linsday, and I'm calling to ask you to oppose this bill. I do believe, as with most of my neighbors, your constituents, that all people should be treated with respect and dignity, and this includes biological women. I do not believe that this bill protects all people. It prevents equal protection under the law because about your biological males or females that now no longer have access or can't request special items from commissary or clothing because they're now basically being discriminated against because they are quote unquote cis-identifying members of the facility. I do not believe that this will at all diminish the risk of litigation because I think it opens up more opportunity for lawsuits because people aren't being viewed equally, male or female. Because I am a woman, I have a heart for women that are vulnerable. And if a male decides arbitrarily to identify as a female so they can get these special protections or whatever protections they feel they are entitled to, this just puts our women at risk, as the caller before or the person before me stated with the examples of rape in prison. This is horrible, and regardless of whether or not the facility chooses to comply with the request for where they would like to be housed, it's a slippery slope, and we're putting our women and our men, we're putting them in danger. So I ask you strongly to please oppose this bill. Thank you.
Thank you. Next caller.
Good morning, Chair and committee members. How's your Monday going? I don't want to repeat a lot that has been said by the other people that have been testifying, but I'm gonna try to make this short and blunt.
Ma'am, before you continue, can you before you make your state? Yes, your name and spelling, please.
Okay, this is Kimberly Fergus, KIMBERLYFERGUS. As I was saying, I'm not going to waste your time as most of the talking points have been duplicated, but I rise in strong opposition of SB 141. This bill is unnecessary. It's duplicative, politically motivated. Nevada already passed SB 153 last session, requiring protections for transgender, non-binary, and gender non-conforming inmates in our state prisons. We don't need another law to force local jails to chase political narratives, especially when there's no evidence of a problem that needs solving. This bill invites massive abuse. First, it's transgender policies. Next, it will be a different standards for other identity groups. Then it's special treatment based on every political category imaginable. Where does it end? This creates chaos in jails, not safety. Under this bill, any inmate can simply claim to be transgender or non-binary to demand special treatment, safer housing, or easier conditions without any verification. It destroys fair and equal standards inside our jails, undermines the authority of our sheriffs, police chiefs, and forces taxpayers to foot the bill without one penny of state funding. SB 141 violates principles of local control, limited government, physical responsibility, and equal protection for all citizens. We should enforce the laws we already have, not keep passing unnecessary mandates to serve political agendas. For all these reasons, I urge you to vote no on SB 141. Thank you.
Thank you. Next caller.
Good morning, committee. This is Bruce Parks, BRUCEPARKS. I'm absolutely adamantly opposed to SB 141 as I was to 153. Once again, we have a bill that does not consider the reality of the situation. Criminals don't care about our laws. They will game the system any way they see they can gain an advantage. Again, there are no provisions in this bill for those people that identify as gender fluid. There are no accommodations that you could possibly make for an individual that wants to game the system and claim one day they're male, the next day they're female. And yes, this is a gender identity, by the way. The third day they claim they're a jellyfish. Please display some common sense and vote no on this bill that essentially enables people with nefarious purposes or folks with according to DSM-5, a mental health issue that would preclude them from getting the help that they need, and the person with nefarious intent being allowed to game the system for their own personal advantages. Please vote no on this bill. Thank you.
Thank you. Next caller.
CYRUSHOJJATY. I'm calling in opposition. I'm just curious, do other species have this social trend? Thank you so much.
Thank you. Next caller.
Chair, the public line is open and working. There are no other callers choosing to testify in opposition at this
time? Okay, thank you so much. Then I will go ahead and open it up for neutral testimony, beginning here in Carson City. Not seeing anyone, and there's no one in Las Vegas. Broadcasting, please open the line.
Chair, the public line is open and working. There are no other callers to testify neutral at this time.
Thank you. Then I will close testimony and welcome Chair Scheibel back up for any final remarks.
Thank you, Chair Miller and members of the Assembly Judiciary Committee. I do want to address a couple things that have come up in opposition, which I think largely stem from a fundamental misunderstanding of the bill. The first one that I want to address is that the text that you're reading in SB 141 is not the policy that the jail or detention center would have to implement. Those are the rules for creating the policy. And there's a good reason for that. Let's look at Clark County Detention Center. You heard from Detective Reese here, who represents the Las Vegas Metropolitan Police Department. And by the way, they have a policy that would comply with the provisions of SB 141. They are already implementing this, and the Clark County Detention Center is large. They house several thousand people at a time. They have multiple sections of the jail just for women, just for men. They do have a section for people with mental health problems. They have a section for juveniles. They have a wide variety of housing options for people who are in their custody. And so their policy speaks to all of those different possible options. Other places in Nevada, we know, have as few as 1 or 2 cells. There are still detention centers in Nevada incorporated into courthouses that have only 1 or 2 cells. Having the same policy for those 2 organizations simply doesn't make sense. And so the purpose of having a law in statute that says that the policy will meet certain requirements is to say that an organization like the Clark County Detention Center can outline in their policy when somebody will be sent to segregation, when somebody will be sent to a mental health unit, when somebody will be sent to a general population. But that makes no sense in a jurisdiction with a single jail cell or even 5 jail cells. And so that organization, that law enforcement agency should be able to write their own policy, which might say that if the only person in our custody is transgender, it really doesn't matter where we house them because they're the only person in our custody. If there are no transgender people in our custody, then men will be housed in one cell and women will be housed in another cell. And then the policy simply has to address, what are we going to do if we do have men and women and a transgender person? And the policy doesn't, the bill doesn't say what the answer is to that question. And it's not supposed to. It's supposed to require the law enforcement agency to think about it ahead of time to avoid a lawsuit if and when that does happen, by saying how they're going to deal with that challenging situation. So I just want to reiterate that we're not talking about what the policy is going to be. We're talking about the requirements the policy is going to meet. Second of all, I'm reticent to do this on the record because I know you all have been sitting on this committee for the last, how long have we been here now? 100? It feels like 100 years. For the last 80-something days, I know that you know the difference between a prison and a jail, but apparently some people in opposition don't. Jail is where a person goes who is incarcerated before they have been tried, before their case on a felony charge has been resolved. Jails do not house people who are serving sentences on a felony, just like prisons do not house people who are not serving sentences on a felony. So a policy that applies to the Nevada Department of Correction, like SB 153, does absolutely nothing for the jails and detention centers throughout Nevada that house people who are still awaiting trial. And that's why we have a second bill in front of you, SB 141, that is very similar to SB 153. And I'm very proud of our callers who noticed the similarities between the two of them, because they are similar, but they're not the same. I am remiss in not having adequately thanked law enforcement for working with me on this bill. I also don't think I really adequately expressed how well so many of our law enforcement agencies are already doing. You heard from Washoe and Clark, who have policies in place that do meet the requirements set forward in SB 141. So anybody who disagrees with jails and detention centers implementing policies in accordance with SB 141, I guess believe that they can do law enforcement's job better than they do because they're already doing this. And that's how we came to the language in this policy. The law enforcement community were incredible partners in developing this bill. I asked all 17 counties to send me copies of their policies, and every single county that has a policy sent it to me. I sat down with the representatives from some of our larger law enforcement agencies, and we compared the policies with the goal not to put anybody on blast, not to criticize anybody, but to figure out what was already working. And that's where we came up with some of the language, like the one that I think attracted a little bit of attention regarding searches of people unclothed for no purpose other than observing their genitalia. Almost every law enforcement agency had a policy similar to this, and so we looked across them and said, what kind of language could we put into a bill that covers the agencies that are already doing this right and gives the guidance we want to the agencies that haven't thought of this yet? And it's not that they're doing anything wrong right now, it's that their policy could be a little bit more robust, that they could take some guidance from the larger agencies who do have to deal with these challenges more frequently and apply them to their smaller organizations. And so I think we had a really productive and collaborative process to look across the policies and take the best of what we already have here in Nevada and encourage the places in Nevada that haven't yet implemented policies to rise to the same standards as some of our best jails and detention centers. And finally, I have presented this bill twice now. I've presented SB 153, and I am frankly disappointed. Disappointed to hear representatives from the Republican Party indicate that when people go to jail, they lose the freedom to be who they are. I think we can all acknowledge that people absolutely lose certain freedoms when they go to jail or prison. But I always thought that our Constitution protected certain inalienable rights. I thought that all of us had the right to our own religion, even when we are incarcerated. I thought we had the right to our political beliefs, even when we are incarcerated. I thought we had the right to express opinions, even when we are incarcerated. I thought every single American still had the freedom to be themselves, even when they are behind bars. And to suggest that our self-worth, our human dignity, our ability to self-actualize and determine our own destinies and who we are depends on whether or not we are incarcerated is incredibly sad to me. I just can't believe that we live in a world where tomorrow we might be debating if people get to practice their religion when they are incarcerated, if people still have the right to their own political beliefs once they are incarcerated. I hope that is a minority of the Republican Party that is speaking up out of turn, and that is not representative of the party that I know, that I've worked alongside for the last 8 years that I've been in this building, passing laws and making legislation that affects all Nevadans. Because the freedom to be who you are is not dependent on whether or not you're incarcerated. And with that, I really urge every single member of this committee's support for SB 141.
Thank you so much. And with that, I will go ahead and close the hearing on Senate Bill 141. The last item of business we have today is public comment. Just as a reminder, public comment, we ask that you keep your comments to 2 minutes, but also it is not to make any comment on any bills heard today, but on any other issues that are under the purview of this committee. So I would like to welcome anyone here in Carson City first that would like to make public comment. Not seeing anyone, and there's no one in Las Vegas. Broadcasting, will you open the lines?
If you would like to provide public comment, please press star 9 now to take your place in the queue. Again, if you would like to provide public comment, please press star 9 now. Caller with the last 3 digits, 673, you are unmuted and may begin.
Thank you. This is Brooke Maylaff calling in. That's BROOKE MAYLATH. Just in general, the comment from an individual on the previous bill.
Brooke, Brooke, we're not making comments on anything regarding the bills that were heard today. So if you would like to proceed with something that's under the purview of this committee, other than the bills that we heard today. And that would include the comments and testimonies.
Caller with the last 3 digits, 673, would you please press star 6 to unmute your phone? Caller with the last digits, 673, please press star 6 to unmute your phone. You may begin.
Thank you. Again, Brooke Maylaff, as I was saying, a referral to an individual that's jellyfish is wholly inappropriate.
I understand, but Brooke,
thank
you, but Brooke, we're not making comments on anything regarding the bills that were heard today.
In general, I would like to be able to, see people keep their comments related to what the bills address and to people as people. Please, this is not about injuring somebody's decent humanity. Transgender people exist. and we have rights, and we try to contribute to society and pay taxes. Referrals, that demean us are wholly not appropriate in any kind of hearing in this building. Thank you for indulging me.
Thank you. Next caller.
Hi, my name is Katrin Ivanov, Ivano Frank, and I just wanted to ask the representatives to represent all of us. Sometimes when there is a problem, your solutions seems to create more problems down the line. And there should be maybe bring a committee where people can suggest things, because more heads are better, and think of solutions out of the box. Like maybe there should be one jail designated for transgenders.
Okay,
and,
ma'am, we're not remarking on any of the bills that were heard earlier today. So please keep.
I'm talking in general.
In general.
I'm talking in general. This is a proposal for a future bill. This is a proposal for you to think on a bill to create. Maybe Nevada can have the first transgender jail. Let us be first in something good for change. We are the first on every negative thing that is out there. Last in education, first on teenage pregnancy, first on women being abused, first on kids born out of wedlock. Let's be first in something good for a change. I'm not discussing a specific bill. I'm giving you suggestions out of the box. And I hope that you will represent more of us in a way that it's money efficient, so you don't create problems down the line that you can be sued from every which way you turn. That's all. I know you're trying your best, but we need you to try some different things. A lot of the bills that you propose.
Thank you so much. Your time is up. Thank you so much. Your time is up. Next caller.
Thank you. Have a lovely day.
Next caller.
Chair, the public line is open and working. There are no other callers for public comment at this time.
Thank you so much. Then I will go ahead and close public comment. That concludes our business for today. I will adjourn, and we will begin tomorrow morning at 9 a.m. You're welcome.